gets entertained.
Drivers too.
Yeah.
Just a thought, it's just something I was thinking of, and I was like, oh.
Of course, the
I don't think
wall
we're liable.
drugstores too.
I don't think the city's liable
Well,
under
drug
those
outside,
circumstances.
If I,
Those
because I
signs all over
use
the
Yeah.
place.
for
That's quite a
Let's
bit.
put it to Bo, because I don't think that we are, just because of officer's
You get a lot of
discretion.
people in there, especially in the summer.
the
Yeah.
way it is written, I have to write a ticket.
The way what is written,
Yeah, whoever started that place and advertised the way they did,
as it's written right now.
Good job.
did a good job. And then it seems to me they also had people, like in the service, et cetera,
There's no discretion.
that
You
were
know,
planting those signs
The
in foreign
laws pertaining
countries.
to,
Where is Wall Drug?
give you just an
Yeah.
example,
Yeah.
domestic violence, in the Colorado revised statutes, it's prohibited. They never get enforced.
And that was probably back in the
And who's
days when
gonna-
you just
Domestic violence,
put it
Yeah.
in, put it in the
We ready?
ground and there was no regulations or
Yeah.
anything.
Okay.
Closer to the baby, the better. Easier
Oh,
to read.
No.
Before you get started.
My
I'd like to
law-
start,
Go
let's
ahead.
get started with this meeting. Start with the Pledge of Allegiance. I pledge allegiance to the flag All right.
Thank you.
Andrea, you want to start with roll call
Yes.
with the,
Tim Oakley,
Here.
Richard Barron,
Here.
Steve Treadway,
Here,
Rick Bain,
Here.
Mark Smith,
Here.
Monty Torres,
here,
and City Council representatives, Mayor Pro Tem Vicky Quinlan,
here.
Janine Anderson,
Here.
Rick Bain,
Here.
Heath Becker, and Mark Smith.
Here.
Okay, at this time, we'll turn it over to Mr. Oakley, who will chair this meeting.
Okay. This is a combined public hearing of the Planning Commission and the City Council on proposed revision of the city's sign regulations, specifically revisions to Chapter 16, Article 12, and Article 14 of the Brush Municipal Code. We will first hear from the staff and then take public comment. Public testimony will be taken for those in support of the proposal as well as those in opposition. Anyone desiring to make comments must first come to the podium, state your name and address before making your comments. Each party will be given one opportunity to speak and must direct all questions to the meeting chair. There is a 3-minute time limit per person. After public comment, the Planning Commission and the council will each take formal action. Okay, as the chairman of the Planning Commission, I will now open the public hearing on the revisions to Chapter 16, Article 12, Article 14 of the Brush Municipal Code concerning sign regulations. Vicki, would you like to open for the
Yes.
council too?
Okay, at this time, I'd like to open the public hearing on revisions, Chapter 16, Article 12, and Article 14 of the Brush Municipal Code concerning sign regulation.
Okay, well, at this time, I'd like to ask for the staff report.
Good evening. I'm going to go over a couple procedural things before I do a more general introduction about the project. The first item is an exhibit I'd like to enter, which is the public hearing notice, which was for this joint public hearing this evening that ran in the Brush News Tribune back on August 12th. And then there's 2 sets of formal actions that'll be happening tonight. The first is by the Planning Commission, and there is a resolution that was in your packet for tonight's meeting that hopefully at the conclusion of things that you'll be taking formal action on that resolution, thereby recommending City Council adopt these new sign regulations. And then the second item in the packet that's going to require formal action is by City Council, and that is a copy of the ordinance itself that would then be the first step of getting the new regulations adopted. So with that, tonight we want to talk about the brush sign regulations and the changes that we'd like to make to those. This whole project started way back in 2008 when the city updated the comprehensive plan, and in that set about goals and objectives for how we want the city of Brush to grow and evolve. And then on the heels of that, we were looking at and updated the land use regulations, since regulation is one of the primary ways that you implement that comprehensive plan. And at that time, we looked at just the zoning and subdivision regulations, and those zoning regulations dated from 1977. And we deliberately left the sign regulations out of that project at that time. And now we've circled back around and are wanting to look at the sign regulations specifically. The regulations Brush has been using date back to 1993, so they're definitely in need of an update. And then you saw over the course of the past year, there's definite support from the community for this project. Back at budget time, you had a letter from the Brush Area Chamber of Commerce supporting this project, asking council to fund this so that we could bring our regulations up to date with current trends and technology. So before we started on this project, we made sure we had very clear objectives in terms of what we hoped to achieve. And there were 4 of those. Sorry, I'm driving here. Maybe not. Andrea, oops. Where do you aim it? Anyway, which one did you hit? Oh, excuse me, operator error. So anyhow, we have 4 project objectives. The first was we wanted to implement the comprehensive plan and promote economic development. We saw consistently throughout the years that City Council chooses economic development as an objective or a primary goal for the city. The second objective was we wanted a format that was user-friendly. The third item is we wanted our rules to be predictable. Those processes and those regulations, we wanted to be very consistent. And then the fourth item is we wanted to make sure that these were legally sound. And just because the world of planning is not as dull and boring as you think, we threw in a Supreme Court decision in the middle of the regulations, Reed v. Gilbert, which really changed the way a lot of communities are going to be looking at doing their regulations in the future. So we should be very proud that what we have in front of us tonight really talks and addresses that court decision and puts us at the forefront of what regulations will start to look like here as we go forward. Now, to start this whole project, we retained the services of a consultant to help us with this, and the name of that consultant is Plan Tools. And the gentlemen specifically that helped with this were Martin Landers and Jerry Dahl. So when we brought those gentlemen on board, staff and the consultant put together a process that was very heavy in terms of public engagement. There were numerous opportunities for the business community to participate in developing these regulations, to making sure that they reflect Brush and will serve our business community for many years to come. That public engagement took the form of 19 stakeholder interviews where Martin sat down and visited with different business owners, members from the chamber, a sign manufacturer, and some of the folks who do enforcement, like the police chief and then the city administrator. We also held 2 community open houses where we had opportunities for the business community to come in and express their opinions about specific options and what things could look like within the regulations. We did a great job of keeping the media informed about this whole project. There's been 8 different items in the newspaper over the past several months, highlighting those open houses, the findings of those, where you can look at the regulations, just the whole process. And then the Chamber of Commerce has been a great partner in this process also, that they have an email network that they were very gracious in allowing us to use to let the entire membership know when those open houses were happening, the fact that we had draft regulations available for folks to look at, and the fact that we were having this public hearing here tonight. And then throughout all this, we had a project website that was hosted by the consultant, and that really, at any point in time, somebody could go on there and look at the findings from those different workshops, the regulations in their various draft form, just everything was always out there that if anybody wanted to take a look, they could. So with that, I'm now going to turn it over to our consultant, Martin Landers, and he'll be going forward with what we got going on with the regs.
All right, thank you, Karen. Well, good evening, council, commissioners. It's good to see you tonight. What I'd like to do is present a bit of an overview of the proposed sign regulations. So I'll start with the table of contents here. And the way this is set up is that we have within Chapter 12 of the Land Use Code, we've got Chapter 16 of Land Use Code, we've got Article 12, which are signs. And there are 4 different divisions. These are purpose and applicability, sign permits, sign standards, and then sign installation, maintenance, alteration, and removal. And within those divisions, there's a total of 15 different sections that we've organized this into. We've also updated Article 14, the definitions, specific to the sign regulations themselves. So there's a whole slew of new regulations or definitions for those regulations relevant to signs. The first division is purpose and applicability. And here we updated the purpose statement to be more comprehensive of the sign code provisions. So we have numerous items within the purposes of the sign regulations now to capture all of those different needs for the sign regulations. We've also reorganized, clarified, and expanded the types of signs that are prohibited, such as signs that are attached to trees, portable trailer signs, billboards. I know we talked about a number of those at our joint work session about a month ago or so. We've also reformatted and updated the sections on legal non-conforming signs as well as enforcement. So those have been tweaked and brought into this particular division of the code. The second division is sign permits. And here we've clarified and updated the provisions for application submittal requirements. So for example, it's much more specific and predictable as to what is required when someone comes in to actually submit an application for a sign permit. We talk about such things as making sure that we show the property lines, where the sign is related to the property line, that type of thing. So again, it's very predictable. We've also added the potential for sign bonus for exceptional design with master plan site development. And this comes into play typically with shopping centers and those types of development where you have a theme, where you have essentially one builder come in there and there's multiple tenants. There's a sign permit now called a master sign permit. That's a part of that process. So you get a little bonus if you put your sign plan together and submit that to Karen. We've also expanded the exemptions for sign permits. So now there's a lot more things that you can have for signs that you don't have to go through the permit process for. Things that you might not even think of as signs, but such things as flags. What we call external use signs, which are those signs that are outside of commercial business that would be attached to some sort of a accessory, such as an ATM sign, those types of things. Temporary signs, most of the temporary signs you don't have to come in for a sign permit for. And of course, sign twirlers. We've all seen them out in the corners, maybe not so much in Brush, but in other communities, but those are exempt from having to come in and get a sign permit. The next division are the sign standards, and this is really the meat of the ordinance. And we've updated and expanded the sign standards by zoning district. So we have sign standards by both the non-residential zoning districts as well as the residential zoning districts, as well as by sign type. So then there's more specific standards by each particular sign type. And we've expanded the types of signs from what you currently had in your code. Again, your current code is about 20 years ago to old. There's been a number of changes in sign technology in the last 20 years. And quite frankly, codes have gotten to the point where they've become very specific about the types of signs, especially when we're starting to get away from that content neutrality issue that we ran into with a Supreme Court case. We've also clarified the measurement of sign height and sign area, and there are some graphics in there that show how that's done. So for example, there's a graphic that shows a freestanding sign and taking that from the final grade all the way up to the top of that sign as being what the sign height would be. There's another graphic that shows a sign area and showing how the different types of signs might have different forms of sign area to measure, and that's clarified. And then we've added numerous tables and illustrations in particular. I'll show you a couple of samples here from the code. This is the standards for residential zoning districts. And if I can get this, nope, push the wrong button. The big one in the middle, thank you. Across the top here, we have the list of sign type, the maximum number of signs, maximum area of signage, and then maximum and minimum height, as the case might be. So along this sign type, we list the different types of signs that are permitted in residential zoning districts, including directional signs, monument signs, site signs, swing signs, wall signs, and yard signs. We have a similar table for the non-residential zoning districts. And I would have shown you that table, but I can't fit it on one slide because it's so long. There's a lot of information in that particular table. I also want to show you some sample illustrations. Most of the sign types have illustrations associated with them in terms of the standards. So for example here, the freestanding pole sign detail shows the maximum height, 25 feet, the maximum sign area, which is 75 feet, the setback from the property line, which is 1 foot. And I should say that these standards are consistent with what's been built, especially along Edison. Now, once we get closer to the freeway, we have another graphic that's similar to this that shows that if you're within 1,000 feet of an interchange, your sign height can go up to 100 feet, and your sign area can go up to 300 square feet. We still have the same setback because that's typically what's happened out there already with those setbacks. It's typical what's happened with the sign heights, and it's typical what's happening with the sign area. One thing we tried not to do is to create new nonconformities. We're trying to essentially customize this code for brush as much as possible. Another example is with the monument sign detail. This shows both for residential districts and non-residential districts. So there's a different standard for monument signs depending on whether you're in a residential district or a non-residential district, and we indicate what those are in this particular graphic for both sign area, sign height, property line is shown here with the setback being minimum 5 foot. The wall sign detail, this was an issue that was very important to the business community in particular, because the current code only allows one sign, one wall sign per building, and that just wasn't working, of course. And what this does is it puts up a calculation so that allows the amount of sign area per linear foot of the facade up to 200 square feet per sign. So for example, if you have a 25 linear foot facade or frontage for your building, you can put in 50 square feet of signage on that building. We don't limit it to one sign. You can have multiple signs within that square footage. We also show the standard for the height. And finally, the example I'm showing here is the projecting sign detail. And these, of course, you see primarily in your CC, downtown zoning district. A lot of shops have these projecting signs. We went to a maximum area of 15 square feet, which is very large for these types of signs. Most folks are going to put in something probably on the order of 6 or 8 square feet at the most. The maximum projection from the wall, so make sure that it doesn't stick out too far. We have a clearance here from the curb. You have to have at least 2 feet clearance from the curb. And then, of course, a 9-foot minimum height so that people can walk under the sign without getting clobbered. Finally, the fourth division in the code has to do with sign installation, maintenance, alteration, and removal. And this is where we've added information on those topics, in particular sign installation, maintenance, and removal. We've provided a provision where permanent signs should be constructed of high-quality, durable materials. This is a topic that we talked about at our joint work session. And we provide for the removal of abandoned signs and the repair of damaged signs. Once we get out of the sign code itself, we're into that Article 14 of definitions, which include definitions for the entire land use code. But there are a number of definitions that we've added for new signs, and these include definitions for what we're calling the amenity zone, which is associated with sidewalk signs, billboards, murals, abandoned signs, the sign face, works of art, electronic message center, which is one of those items that's a new technology that's occurred, of course, in the last 20 years that we've addressed in the code. And then several associated terms. One thing that we did see in the current code was there was a number of definitions that needed to be tweaked, just due to a variety of different reasons, but we've updated those definitions so that they're consistent with the rest of the sign regulations. So So that's also part of the revisions that were made under the definitions section. To summarize then, the proposed sign regulations address multiple project objectives. Karen kind of went down the list here. As I mentioned, the sign code has been customized for Brush, and it is based on feedback that we received from the 19 different interviews that we did with various folks within the community, as well as the 2 public workshops that were held and the feedback from the joint work session. We're also in the process of producing a sign guide. And we talked about this during the interviews. And I've actually brought a prototype with me tonight. We're still working on some refinements to it, but basically it's going to look like this. It's just a small brochure type of a handout that will provide applicants and others with information about the sign regulations. We can't, of course, put the entire code in here, nor would we want to, but it's basically just something that makes it a little bit more user-friendly. One of the goals of the project was to make the code more user-friendly. We think we've done that through the addition of the illustrations and the tables and the way that we've consolidated and organized information. So with that, I'll conclude my presentation and am available for any questions from the board or the commission. Thank you.
Thanks, Martin. Okay, are there any questions from the commission or the council that they would like to ask the consultants or Karen? Oh, sure. Okay, go ahead.
Thanks. Pardon me. Thanks. I'm Jerry Dahl, and I'm pleased to see all of you. I didn't prepare anything like formal remarks, and it occurred to me sitting here that something that Karen had mentioned you might want to take special notice of and actually be proud of, and that is the changes that we made really midstream when we got a 9-0 decision from the United States Supreme Court in the middle of June, and those are unheard of. You don't get 9-0 decisions. You're lucky anymore to get a 5-4 decision, or a 6-3 decision out of the Supreme Court. But this was a 9-0 right in the middle of June, which of course was right in the middle of this project. And the reason I mention it is because, as Karen pointed out, it will really change the landscape in terms of what local governments do about sign regulation, and in particular about the content of signs and whether, and frankly you can't, and anymore can't, certainly under the Supreme Court decision, regulate signs based upon what they say, what their content is. We already more or less sort of knew that, but honestly, most sign regulations that were written 20 years ago have categories of sign that the only way you know how to regulate that sign is by reading it first. So really, when you think about it, you're regulating that sign based upon what it says. Well, what's wrong with that? You might say, well, we have the First Amendment that really restricts the degree to which your free speech, even if it's commercial speech, eat at Denny's, that's still speech. And pure political speech, for example, campaign signs, that's not commercial speech. That's what they call pure First Amendment speech, is even more highly prized and protected. And we all knew that, frankly, but over the years, cities had developed regulations that relied upon looking at the content to determine how you could regulate that sign. And the Supreme Court was really very clear in the decision in the Reed versus Gilbert case. That's Gilbert, Arizona, and it's a town, I think, outside of Phoenix. I've never been there. It's down there. Honestly, some of the dissents are not really dissents, concurring opinions. That's the deal. It's a 9-0 decision, but it wasn't like there weren't concurring opinions. The decision was written by Justice Thomas, and so you can expect there were some concurring opinions from kind of the other side of that bench, but concurring in the result and concurring in the decision that you can't regulate signs based upon content. And I think we'll probably see a little bit of relief from later cases, because there are some few circumstances in which you really do need to determine the regulation based on content, And it's not that you can't do that, but the courts have always said in First Amendment territory, and I'll stop in a minute with this Supreme Court lecture, which probably be mused at, but it's fascinating because honestly, I think Brush is probably the first city in the state to apply that decision. And I think quite likely your code will be a model for a lot of people in terms of how we've been able to comply with that decision. But, you know, the courts say you can regulate only according to time, place, and manner, but not content, except if the subject matter is of compelling governmental interest and there's no less restrictive way of dealing with it. And you go, well, give me an example of that. Signs that look like stop signs. Think about it. Public safety, clearly, having to do with whether a driver is going to stop or not. And that's clearly a compelling governmental interest. Prohibiting them, as we do in this code, you'll notice there's a prohibition for signs that would cause confusion with traffic direction signs, is probably the least restrictive means of achieving that. So that's an example where you can actually do that, but it's really very limited. So what we did in going through the code was to say, gee, this restriction that we're proposed putting in the code, do you have to read the sign to know whether it applies? And in each case, if we said yes, we said, well, what's another way of achieving that? And we went through and scrubbed out almost all of the references that would rely upon reading the content of the sign, with some exceptions, and the one I mentioned is one such. But honestly, it's the only way you can do it, and there is a compelling governmental interest in doing it, and so you're allowed to do that. But it's much more narrow than really any government used to do. The last point I guess I'll make is so many cities have, and you no longer do because we complied with the court, restrictions on political signs. We've all seen them. They can be this size and shape, and they can be up X days before the election. They have to be taken down Y days after the election. Well, how do you know to apply that restriction? Well, because you got to read the sign, and it's got to say vote for Jerry Dahl, and then you know it's a political sign. You know it's subject to all those restrictions. Well, you'll notice those restrictions aren't in this code anymore. And if it's a political sign, if I want to put up vote for Jerry Dahl, that's going to be a yard sign. And the code allows me to put up yard signs. It does not have a limitation on the time frame, because the courts would get into, well, if you can put up vote for Jerry Dahl, why can't you put up I don't like taxes, or I do like taxes, or I'm in favor of the Second Amendment, or I'm not? And what should be the time limit for that? And again, people had to read the sign to know what it was, and you just can't go there. But I think we've pretty successfully shifted the whole view to, well, what's the sign type? Is it an awning sign, a yard sign, a wall sign? And what should be the restrictions around those? And you'll notice in all those cases, you don't have to read the sign to know how it's restricted. You just have to know physically what size and shape, what kind of sign it is. I really believe that that's the future for sign regulations, and I'm delighted that, you know, Brush, we were in the middle of the Brush project, and I have to thank you for the opportunity, really, to give me the chance to be able to apply a 9-0 Supreme Court case in the middle of a project. It's not something I'll probably ever be able to do again. So thanks for that. Questions for any of us?
The pamphlet that Martin had, is that a finished pamphlet, or?
No, it's not.
Oh, I was going to say, I was going to take a look at it, but it's just an idea of,
Draft right
okay,
now, yes.
okay,
I should be finished within the next 30 days or so.
okay.
Anyone else have any questions for Martin or Jerry or Karen?
I have one small question. When I talked about the wave banners that we talked about allowing, it says they may be placed in an amenity zone. What defines or constitutes an amenity zone?
Okay, let me get to the definitions here, and I can cite that for you. So the amenity zone means an area in the CC zoning district within a public right-of-way, along or adjacent to a sidewalk, which is pretty much, you know, downtown you've got those sidewalks.
Okay.
And they're public right-of-way. That offers protection to the pedestrian from vehicular traffic. It contains street furniture, planters, trees, landscaping, utilities. Essentially that section between the sidewalk and the street that they put a variety of different
Okay.
amenities into.
I just didn't know what where we're limiting where the traffic's gonna flow.
Right.
You know, which side, is it gonna be on the business side or toward the street side so that your pedestrian traffic can go through
Yeah.
the middle?
So that would be the street side, yes.
Okay, street side, okay.
Anyone else? Okay. This time we'll open it up for public testimony, either in favor of or opposition of. Keeping in mind that as you approach the podium, would like you to state your name and address, and remember you have 3 minutes. So if there's anyone that would like to come up, you're welcome to at this time.
Somebody left their glasses here. I'm Dean Graham, 1018 Colorado, Brush, Colorado. I've got 3 things to mention here, just to clarify a couple things. Not that I'm against them, but on the putting signs in windows, page 3, section 3, it says windows are prohibited. But page 7, section 6, it says they're okay. Page 19, section 1, it says they're okay. Page 11, it says you can cover 50% of windows. So I have nothing against putting signs in windows, but I think this one on page 3, section 3, should be clarified. Then on page 5, section E, it talks about if the city has to do stuff with signs, they can charge 10% interest. I know, and Bo, I think will vouch for this, if it goes to court, they're only gonna let you charge 8%, so if somebody wants to save 2%, they put Bo to work and they can go to court. Then, page 25, section 3, the computing square footages of signs. I've got signs on my buildings, and now the way it used to be, Martin, right? The way it used to be was explained when I put the signs up. It was total height by the total width, even though some of the lettering was different, you know. And the way I understand it now is, you can do zigs and zags between your lines. So actually, at the time, I probably got, well, I got a variance, so I could get as much on as I got. But I probably wouldn't need it doing the zigs and the zags, because before, like I said, it was total height by the maximum width. So I've got that straight in my head, right?
Yeah, I can't tell you exactly what the old code, what said regarding that, but I know in the new code it's very specific about the, as you call them, the zigs and the zags.
Yeah.
Where you can, if you've got a message that is, doesn't fit neatly into a box, it really measures around that message.
Got it. That's what I thought I understood, but I thought I'd ask. Okay, that's it. Thank you.
Thank you.
Hi, my name's Mario Palumbo. I'm at 121 Clayton Street. You know, obviously the signage regulation needed to be revised because there were a lot of gaps in there. I'm a little concerned though with the legal non-conforming signs and the enforcement portion of your proposed regulation. You've got deals in here wherein most of the signs downtown will be non-conforming within any length of time, in very short length of time as well, because most of them are either in a needed state of repair, or, and it says in here that if they're destroyed to the extent of 50% of its value may not be recognized or repaired except in conformity with this article. It also goes on to talk about enforcement. You're talking about fines of $300 for each day that it's in non-compliance after notice has been given. You know, the 18% or 10% or whatever doesn't seem to be that big, but that fine is a little steep for where we are. We're not Parker, we're not Highlands Ranch, we're not Denver. So it's, with some of what you have here, it's a little harsh. There were a few other things in through here. I think that you guys do need to take the time and the effort to look through here and see what fits our community and what actually doesn't. There's a lot of good in here. There's a lot of other stuff that's not quite so good. So I would just hope that you would take a look at that before you actually review it. We were never interviewed, and by the time that I did find out about the one workshop, it was already too late. So I just thought I'd let you guys know that. Thank you.
Thanks.
My name is Ron Prasher. I live at 2320 Emerson Street in Brush. Appreciate that all of this work has been done, and I think for the most part it's very good. And I do have a few questions. For example, on page 10, and I should have attended the second meeting. I attended the first one, but wasn't able to attend the second one, and I know that's a meeting for give and take. On page 10, marquee signs. It talks about 20 square feet. I'm not sure if that means both sides. I'm thinking of the Sands Theater marquee sign, if that would work or not. It's a historical building, been there many years with that sign. Would that be a problem? Does that sign have to come down or get a variance? Okay. Then A-frame signs is, as talked about on page 11. It talks about 8 square foot. Does that mean that both sides of an A-frame sign are 8 or 4 on the side? Some of the A-frames we have at the chamber probably wouldn't qualify. Those are fairly new. I could be wrong there, but I think it's, and maybe it is both sides. Both sides are 8, and if so, there wouldn't be a problem. On page 3, when it talks about various things, I'm not sure if I understand if those listed there are exceptions or not. But if they're not exceptions, then the idea of signs on trailers, many times when you have special events, you'll have a sign on a trailer and you move it to various parts of the city, and it's just up for a couple of weeks or so. If those aren't exceptions on page 3, then if I'm reading it right, you couldn't do that. That's signs on trailers. And then the signs in windows, the same as has been mentioned. If on page 3 it means that you can't have signs in windows that would obstruct, and then in 2 other places it says that you couldn't have signs more than 50% of the window, and those other places I think are like, well, page 3, I guess I don't have written down, but in the signage area, 10, 11, 12, and through there, and two places it says that you can do that. And it might be that just, I don't understand what's happening there, but have those concerns. And thanks to the council and the staff for doing this. I think it's very helpful.
Anyone else? Okay, would like to address some of those questions for us?
On the enforcement items. Hopefully this mic is still on. It's a small room. I don't have to worry about that. Yes. A couple things on enforcement. On non-conforming signs, legal non-conforming signs, the language about the 50% of its value and if it's just damage destroyed to the extent by police documented vandalism, it can be repaired within 90 days but not thereafter. That's on page 4. That's in your existing code. That particular provision wasn't changed from your existing code at all. I get it that non-conforming, the degree to which signs are made non-conforming by new code is an absolute legitimate interest of people. And I guess I should mention and highlight what Martin said earlier, which was the intention was to, as much as possible, legitimize what you have in place, and we've done a lot of that. I agree that to the extent a sign gets enlarged or reconstructed or needs to be repaired, then a permit is required, and if it's non-conforming, it would have to be made conforming. But I guess I would also stress that this is generally the approach you already have, and you have that approach throughout your land use code. This is not just signs, it's any other, most land use codes have that kind of approach. You're a little more lenient than some other cities when you talk about police documented vandalism. That's kind of unique to Brush. I've never really seen that elsewhere. And it's also true that you have a provision that permits normal maintenance of a sign and a change of copy, and that does not trigger enforcement on an otherwise legal non-conforming sign. You know, those are all the protections that are in place, that if you're doing something that's made non-conforming by this code, you can keep doing it, and you can maintain it, you can paint it, you can change the copy, and keep it the way it is, and the city will not bother you. So I want to underscore that. The $300 a day is actually low as compared with most cities have gone to $1,000 a day as, let me just say this, as the limit that their judge has. The judges in practice don't typically apply those kind of fines. The $300 a day is your standard enforcement, unless Bo tells me it's different, but that's for any code violation throughout the cities. And we didn't invent that. That did not get invented for sign code. That's for loitering, that's for everything. And I think it's important to remember that it's the judge that makes the decision. It's not a required fine, it's the judge's authority. So frankly, the upper limit is less important than what the judge chooses to do in an individual case. I don't feel strongly, the third thing I think I put down on enforcement was the 8% versus 10%. I don't feel strongly about it at all. I think the 10% probably came over from your old code. I'm certain we didn't change that. I think it's well within your authority as the commission and the council to recommend it be a different number. That's the percentage that's charged upon unpaid fines and whatnot, and charges. In practice, my full practice is just representing cities and the city attorney and other places. And in practice, cities are delighted to get compliance and aren't as worried about the interest. They're delighted to get paid whatever the amount is when they finally get it paid. So that tells me that while you should still have some kind of penalty, all of us suffer that in our private lives, don't we? When we don't pay something on time, the bank charges you, and that's that's just a feature of life, and it shouldn't be any different if the city has a bill that isn't being paid to the city. Having said that, I don't feel strongly about what percentage of interest you place on an unpaid bill under the sign code. It probably should be consistent with what the rest of your code says, because otherwise you have some problems kind of keeping track, and I'm not sure, maybe Bo can help us on what the rest of the code says about percentage charges on unpaid fines or fees or other things. But that's kind of my list of enforcement items. Bo, what does it say?
I don't have a definitive answer on that without looking it up, Jerry.
Yeah. You could certainly say consistent with, and we could find it, and we can make it consistent with what you have elsewhere, to the degree it isn't more than 10%. If it's less, I'm fine with changing it. And you'll notice one of the motion that we've set up for adoption here directs your staff and your consultants to make such technical changes as necessary for conformity, numbering, and whatnot. In my opinion, this fine number would fall in that category. I think probably don't want the sign code to have a different percentage on unpaid fines than other parts of the code, just for enforcement, and we're happy to make that the same, whatever it is.
Okay, well, let me take
Yeah.
a few more questions here. There was a question regarding the signs and the window signs in various locations in the code. on page 3, that's under the section on prohibited signs. This is actually a provision that came out of your current code. It's a fairly standard provision in sign codes, that any sign that obstructs any window, door, fire escape, stairway, ladder, opening intended to provide light, air, ingress, egress for any building or structure as may be required by law. That's fairly public safety type of clause that's put in there. What we've done different here is that we've added provisions for having window signs, both temporary window signs as well as permanent window signs, up to 50% of the window. So basically you have to have a minimum transparency of 50% of the window, but you can have window signs. So, and that's what's cited in other sections for the code.
And if, the concern is, well, gee, does that as may be required by law phrase apply to the whole list? I think maybe that was part of the comment. I wouldn't have objection, again, under the technical changes of authority that hopefully you'll give us, to stick in the word all before as may be required, because then what you're saying is everything in that list is sort of generated, or is, you have the as may be required by law as something that modifies everything in the list, not just the stuff immediately before it, which I think is the egress egress. If that was a concern, that would be fine. Sorry.
Okay, no, that's fine. Another question that came up had to do with the sidewalk signs and the square footage, and it is 8 square feet per sign face, so you get that both for both sides of the signs. And that's actually the largest that you see of those types of signs. It's a pretty large sidewalk sign, so that should comply with what everyone has out there right now as well as what anyone wants to put out there. So it's not a total for both sides, that's per sign face. And for marquee, yes, and there's actually 3 potential signs for sides for marquee signs that you can have the 20 square feet, maximum 20 square feet for. I don't know exactly what the size of that sign is at this point. We can certainly verify that, and if there's a concern about that, we could certainly make sure that whatever minimum we come up with meets that standard. In any event, it won't require that sign would come down one way or the other, because it would become a legal non-conforming sign, worst case scenario, if it wasn't complying with this particular standard, just like any other sign in town, which means they can keep it for as long as they like. But there are some conditions and restrictions on that would occur. But again, the intent is to make sure that we are providing for what's out there right now to the extent possible, so we can certainly check that and make sure the size is compliant. Was there anything else that? Trailers are prohibited under this. We've had some extensive discussion about this at our joint work session. We talked about portable trailer signs, and we came to the conclusion that we should prohibit them. So that was fairly clear from the direction that we received.
I think that was the list, but those questions are, and our answers prompted any further questions from the commission and council. We'd be happy to take it.
Anyone have any other questions or comments? Okay. As the Planning Commission Chair, I'm now going to close the Planning Commission public hearing. And this is resolution number 2015 PC01, resolution adopting and recommending the revision of Chapter 16, Article 12, Article 14 of the Brush Municipal Code concerning signs. And at this time, I'd like to ask for a motion to recommend approval of the resolution as the final report of the Commission under CRS 31-23-306.
Who do you want there?
Be someone from the planning commission to,
I'd make that motion.
okay. We need a second.
Second.
Okay. It's been motioned and second. Is there any discussion from the planning commission? Any more discussion on it?
I have a question, and that is, what Jerry, had said about the changes. That includes those changes then in this resolution?
You're talking about the change with respect to the yard, or the window signs, including the word all? Is that?
Well, and then the other things that he mentioned.
8%.
Yeah, I don't have a problem dropping the interest rate if we find that other sections of the code are lower.
I'm just trying to clarify what we're voting on.
Yeah.
Are we voting on those changes that you suggested?
What I think you're doing, the resolution itself, when you read the resolution, it says that the planning commission recommends this draft with such additional technical revisions and corrections as the director of community development, city's technical consultants, us, deem necessary. That would clearly apply to the 8 versus 10% question. So in adopting this resolution, you're giving us that, you're making that recommendation, you're giving us that authority, assuming the council basically also approves. So you covered it if that was your question.
Any other discussion? Okay, I guess we're ready to go to a vote.
Chair Tim Oakley,
Yes?
Chairman Rich Viren,
Yes.
Chairman Steve Treadway,
Yes.
Commissioner Rick Bain,
Yes.
Commissioner Mark Smith,
Yes.
and Monty Torres.
Yes.
Okay. At this time then, I will turn the meeting over to our Mayor Pro Tem, and she can do the first reading.
Okay, so again, this is in regards to the first reading of ordinance number 836-15, an ordinance repealing and reenacting Chapter 16, Article 12 of the Brush Municipal Code concerning signs and adopting and amending certain definitions in connection therewith. So, at this time, I'd like to declare the final report of the Planning Commission as received by the council that we just heard. Okay? I'd like to close the public hearing of the council at this time. And if I can get a counselor to actually introduce the ordinance.
Do you want two, Vicky, for reading and adopting and amending, or do you just want one? Will one be sufficient?
Just one.
One,
Okay.
yeah.
I move that we adopt the first reading on ordinance number 836-15, an ordinance repealing and enacting Chapter 16, Article 12 of the Brush Municipal Code concerning signs, and adopting and amending certain definitions in connection therewith.
Okay. Do I have a motion to approve the ordinance on the first reading and publication?
I'll make a motion that we approve the first ordinance on the reading and publication of the ordinance 836-15 as per our discussion.
Okay, do I have a second?
Second.
Okay, it's been moved and second. Any discussion from council?
So we are saying that the dropping the interest rate from 10 to 8%, regardless of what other sections of the code, do we want to just drop it to the 8%?
Every time a judge has worked in my favor, it's always been 8%. It's never been higher than 8%.
Yeah, I don't have a problem just saying we'll take it to 8% on that part of it and include the word all with respect to window signs for clarification. Okay.
Terrific, we can do that.
Okay.
Just
Yes.
wanted to ask one other clarification. Would you like us to make sure that the marquee sign is within the parameters that we're setting out for the area?
Yeah.
Footage?
Yes.
Would that be
I-
the third item?
I think so.
I put that third
Adjust
item in
it
there,
If necessary.
if necessary.
If necessary, yeah.
Correct. Okay, any further discussion? Okay,
Okay. Mayor
Vote.
Pro Tem Quinlan,
Yes.
Counselor Bain,
Yes.
Counselor Anderson,
Yes.
Counselor Smith.
Yes.
Okay.
Okay, very good. I think we have a good product. We've had good input from the community on this regulation and this ordinance. I think it's a good product that Martin and Jerry have come up to help us put together that's, you know, something that's user-friendly and predictable, and it's legally sound. And I think we are going in the right direction. And I'd like to thank those who made public comment today on this as well. Thanks for coming down, taking time to come down and express your opinion on that. So at this time, I'd like to adjourn the meeting. Do we need it?
Thank you very much.
Yep, thank you.
Appreciate it being here.